She said it loud enough for the back row to hear. "That is not the law," not whispered to co-counsel, not muttered under her breath. She turned partially toward opposing counsel, partially toward my bench, and she said it like she was correcting a student who'd gotten something wrong on a quiz. The courtroom went quiet in that particular way it does when everyone in the room understands that something has just shifted. I set my pen down. I have been on this bench for 19 years. I have watched attorneys fall apart under pressure, watched defendants unravel at the worst possible moment, watched juries make decisions I still think about on quiet Sunday mornings. I have seen a great deal of behavior inside this room, but I will tell you this. In 19 years, I had never seen an opposing counsel interrupt a closing argument to correct the law in front of the jury, until that afternoon. Let me take you back to the beginning of that week, because what happened on Thursday only makes sense if you understand what the courtroom looked like on Monday morning. The case was a civil dispute. Breach of contract, fraudulent misrepresentation, the kind of case that looks straightforward on paper until you start pulling at the threads. A small business owner, I'll call him Mr. Aldrin, had entered into a partnership agreement with a man I'll call Garrett Voss. Voss had brought Aldrin in as a co-investor in a property development venture. The paperwork was signed, the money changed hands, and then, over the following 18 months, the project quietly ceased to exist while Voss's personal accounts, according to the plaintiff's filing, did not. Aldrin had originally hired a general practice attorney, a man named Paulson who did solid work, wills, small contracts, the occasional fender bender, a decent enough lawyer for most situations. This was not most situations. Paulson had filed the complaint, handled the early discovery motions, and done nothing technically wrong. But by the time the case reached trial, it was clear to everyone in that room, including, I suspect, Paulson himself, that he was carrying a weight slightly beyond his grip. The defense, meanwhile, had arrived with a woman named Claire Abernathy. Abernathy was not loud. She was not theatrical. She did not pace dramatically or pause for effect in the way some attorneys do when they believe the pause itself is doing legal work. She was precise. She asked short questions. She listened to answers in a way that made witnesses uncomfortable because they could not tell what she was building toward. On Monday, during opening statements, Paulson spoke for 14 minutes and covered every element of the complaint. He was thorough, he was organized. Abernathy stood, buttoned her jacket, and spoke for 4 minutes. She said, "Mr. Voss signed a contract. That contract had conditions. We intend to show you that those conditions were never met by the plaintiff. Not fully, not legally. And that matters because in this state, an agreement is only as binding as the obligations both parties actually honored." She sat down. I watched 2 jurors in the back row exchange a glance. By Tuesday afternoon, Paulson had called his first witness, Aldrin himself. Aldrin was a careful man, mid-50s, measured with his words, the kind of person who thinks before he speaks and sometimes thinks a beat too long. He walked the jury through the timeline, the initial meetings with Voss, the handshakes, the signed paperwork, the wire transfers. Abernathy's cross-examination took 11 minutes. She didn't attack Aldrin. She didn't raise her voice or imply he was lying. She simply asked him, with genuine-sounding curiosity, to walk her through the specific deliverables he had agreed to provide under the contract. Aldrin described them. She asked whether a particular milestone, a due diligence report that Aldrin was contractually obligated to provide within 60 days of signing, had been delivered on time. Aldrin paused. He said he believed it had. Abernathy held up a document, asked me to admit it. I reviewed the stipulation, admitted it into evidence. She handed it to Aldrin and asked him to read the date aloud. He read it. It was 41 days past the contractual deadline. Aldrin said the delay had been communicated to Voss verbally. He said Voss had agreed to an extension. Abernathy nodded slowly. "Is that verbal agreement documented anywhere?" Aldrin said no. She thanked him, returned to her table, made a note. I looked at the jury. 3 of them were writing. That is always worth noting. Paulson called 2 more witnesses Wednesday morning, an accountant who testified to the flow of funds and a former associate of Voss's who painted an unflattering picture of the man's business ethics. Both witnesses were credible. The accountant especially, she had records, she had spreadsheets, she had deposited checks with timestamps. Voss's money had moved in ways that were, at minimum, difficult to explain through legitimate business operations alone. Abernathy's cross of the accountant was brief. She established that the accountant had been hired by the plaintiff, that her analysis was based on documents she had been given rather than a full audit, and that she could not independently verify the completeness of the records she had reviewed. Clean, economical, no drama. By Wednesday afternoon, I suspected Paulson knew he was behind. Not on the facts were reasonably strong. He was behind on narrative. Abernathy had spent 2 days quietly building a frame around the plaintiff's case. that Aldrin himself had not fully honored the agreement, and that in a contract dispute, that matters. It was a defensible argument. Whether it was a winning argument depended entirely on closing. Thursday arrived. Closings were scheduled for the afternoon session. I had eaten lunch at my desk. My clerk, a young woman named Renata who had been with me for 3 years and had learned to read my moods accurately, brought me coffee without being asked. We took the bench at 1:15. Paulson went first. He stood at the lectern and delivered what I would describe as a competent, earnest summation. He walked through the evidence methodically. He reminded the jury of the wire transfers, the promises made, the money that had vanished into what he called the fog of Voss's accounting. He asked them to consider what justice looked like in a case where a man had trusted a partner and been left with nothing. He spoke for 32 minutes. It was not a bad closing argument. For most cases, in front of most juries, it would have been enough. Then Abernathy stood. She began calmly. She thanked the jury for their time, brief, not excessive, and then moved directly into the substance of her argument. She reminded them of the missed deadline. She reminded them that no written extension existed. She reminded them that under the language of the contract, and here she read a specific clause aloud, slowly, without editorializing, performance by both parties was a condition precedent to enforcement. And then she said something that I believe she calculated carefully. She told the jury that the plaintiff's own attorney had misrepresented, in his closing, what the law requires for a breach of contract claim to succeed. That under the applicable standard, a party who has failed to meet their own obligations cannot recover for the other party's breach without first demonstrating substantial compliance with their own duties. She said, "What Mr. Paulson told you about how breach of contract works in this state, that is not the law." That was the moment. Paulson was on his feet before she finished the sentence. "Objection, Your Honor." I looked at him. "On what grounds, Counselor?" He opened his mouth, closed it. She's mischaracterizing the legal standard." I turned to Abernathy. "Counselor, you're making a legal argument to the jury. I'll remind you that it's my job to instruct the jury on the law, not yours. You may argue how the law applies to the facts. You may not instruct the jury on what the law is." Abernathy nodded once. "Understood, Your Honor." "I'll rephrase," and she did. She stepped back and told the jury, "When the judge reads you the instructions on breach of contract, I'd ask you to pay close attention to the section on performance and substantial compliance. And I'd ask you to hold that instruction next to what the evidence actually showed about Mr. Aldrin's own conduct under this agreement." She sat down. The room was still. I looked at the jury. Not one of them was writing. They were simply sitting there, several of them looking at Paulson in a way that made me understand exactly what had just happened. Abernathy had done 2 things in 30 seconds. She had planted a seed of doubt about opposing counsel's reliability, and she had told the jury, without technically telling them, exactly where to look when I read the instructions. Paulson stood to request a brief rebuttal opportunity. I allowed it. He used it to restate his theory of the case. By then, I suspect he knew it wasn't going to be enough. The jury deliberated for 2 days. They came back on a Friday afternoon. The foreperson, a retired high school principal named, according to the jury list, Mr. Hecht, stood when I asked for the verdict. He was a straight-backed man. He held the verdict form level with both hands. They found for the defense on the primary breach of contract claim. They found for the plaintiff on a narrower claim, one related to a specific misrepresentation Voss had made in a written communication prior to the contract signing. Damages were awarded, but they were a fraction of what Aldrin had sought. Aldrin sat very still when the verdict was read. His attorney put a hand briefly on his arm. Voss, for his part, showed no visible reaction. He had been that way throughout, a man who had learned, somewhere along the way, to keep his face completely neutral in rooms where things were being decided about him. Whether that calm was genuine or practiced, I couldn't tell. I rarely can. Abernathy gathered her materials without ceremony. She shook Voss's hand, exchanged a word with her co-counsel, and left the way she had entered, without theater. Paulson filed a motion for reconsideration the following week. I denied it. The verdict was legally sound. The jury had followed the instructions. They had looked, as Abernathy had suggested, at the section on substantial compliance, and they had found what she told them they would find. I spoke with Renata afterward. She had watched the whole trial from the clerk's station, which gives a view of the courtroom that I don't have from the bench. She can see the jury straight on. She told me the jury had been watching Abernathy from the first day of testimony, not in an obvious way, just watching, the way you watch someone who seems like they know something you don't yet know. I thought about that for a while. What I keep returning to when I think about that case is not the verdict itself. Verdicts are outcomes. They belong to the record. What I keep returning to is that Monday afternoon, 4 minutes of opening statement, delivered without a single wasted word. The jury was listening from that moment, not because of what Abernathy said, because of how she said it, like someone who had already seen the end of the story and was simply waiting, patiently, for everyone else to catch up. That is a particular kind of lawyer, and when you're standing in front of 12 strangers asking them to decide something that matters, it makes all the difference in the world whether the person beside you is that kind of lawyer or isn't.